My name is Christine Benjamin, and I'm the Breast Cancer Program Director at SHARE. Before the presentation begins, I'd like to tell you just a little bit about SHARE. SHARE is a national nonprofit that improves the lives of women affected by breast or ovarian cancer through experienced peer support, accessible education, and innovative outreach, always for free. It meets women wherever they are, especially in medically underserved communities, with the insight of women who have been there too, creating a nationwide network where women are empowered and feel less alone. SHARE's free services include support groups, educational tools, expert-led webinars and presentations, a national helpline, online communities, and survivor patient navigation. For more information, visit our website at sharecancersupport.org. All participants will be muted during the presentation. When the presenter finishes speaking, we'll open up for questions and answers. You're welcome to submit questions during the presentation through the question pane in the control panel on your screen. When asking questions, remember the presenter is unable to give specific advice, so please keep your questions general in nature. The webinar is being recorded and will be available soon. So let me introduce the Cancer Legal Resource Center, which was created to help address the legal issues faced by people with cancer. They're committed to providing information and resources about cancer-related legal issues to individuals within the national cancer community at no cost. The Cancer Legal Resource Center provides information through its national telephone assistance line and online assistance program. Additionally, they conduct outreach and educational programs on a variety of subjects, ranging from maintaining employment through treatment to taking medical leave and estate planning. So we're so lucky to have Stephanie with us today. Stephanie, it's all yours. Thank you so much for being here.
Great. Thank you so much for having me. So my name is Stephanie Fahuri. I'm the director of the Cancer Legal Resource Center. And I just want to give you a heads up really quickly. I'm going to be covering quite a bit of material during today's webinar, and I'm going to do my best to leave some time for questions at the end. So my apologies in advance if I go a little bit quickly. So just to recap, the CLRC is a program of the Disability Rights Legal Center. We're based in Los Angeles, California, but we run a national program. And our mission is to provide information and resources on cancer-related legal issues to patients, survivors, caregivers, healthcare professionals, employers, and literally anyone else who might be coping with cancer. We do not provide direct legal representation or legal advice, so the webinar today is a provision of information and resources, hopefully to help empower you to enforce, some of your employment rights or insurance rights on your own. We do have a number of materials available if you have additional questions or questions on other topics. So the main one right now is our Patient Legal Handbook. It's available to download for free on our website, and we are also in the process of shipping bulk orders to hospitals, facilities, and other nonprofit organizations. And it covers basically the top 20 most common legal questions that we hear about from people either on our telephone assistance line or when we're out in the community providing workshops. We're really grateful to our sponsors, Breakaway from Cancer and the American Cancer Society, which have enabled us to provide this resource at no cost. Additionally, we do in-person workshops and other webinars on a national scale. So please feel free to check out our website, cancerlegalresources.org, for other publications and also to register for our upcoming webinars. So I mentioned that I'm going to do my best to leave some time for questions at the end of the webinar today. If I'm not able to answer all of the questions that you have, either because we've run out of time or because I don't know the answer off the top of my head, please feel free to reach out to us either online or by phone. The best way to reach us for our telephone assistance line or online assistance program is through clrcintake.org. You can fill out an online intake form there, and we'll do some research on your questions and provide you with some information and resources that are applicable to your situation. If you are uncomfortable or unable to fill out the online intake form, you can always leave us a message at 866 the CLRC and let us know the best time to reach you, and we'll contact you by phone to complete the intake. And just as a final reminder, all of the information and services we provide are free, but we do not provide direct legal advice or representation. So without further ado, let's move into the substance of today's webinar. So we called it Cancer and the Law. We've sort of drilled it down to 5 major legal tips that we want to share to help educate you about what your rights might be in a number of different arenas. So number 1, it's the patient's responsibility to understand his or her insurance coverage. Number 2, don't take no for an answer. Number 3, request accommodations before your work performance is affected. Number 4, you may be able to take time off of work and keep your job. And number 5, document your end-of-life wishes before it's necessary. So CLRC tip number 1, it's the patient's responsibility to understand his or her insurance coverage. We recognize that this is basically an impossible task for some patients, but unfortunately, this is the reality. People often make the mistake, and I've made this mistake in the past, assuming that the doctors, surgeons, nurses, other health practitioners who are treating us have to know what's covered by our insurance plans or what isn't, or to what extent. Unfortunately, that is not the case. A lot of our healthcare providers, as wonderful as they are maybe not actually even familiar with your insurance plan, nor are they necessarily required to be. So even if your healthcare provider says that they will call the insurance company to find out what your out-of-pocket costs may be or whether or not a certain service is covered, it's always a good idea for patients to become familiar with their plans so that they understand, different terms or payments that are going to be required from your plan. That can help prevent unforeseen costs. And there's actually a number of different ways that you can access this information. So generally speaking, most insurance companies and policies are available online. Usually there's some sort of online portal that you can set up an account for and access all of your plan documents. If you have trouble with that, or if for whatever reason your information is not available online, you should be able to contact your insurance company or your HR department if you get insurance through work to get additional documentation like your evidence of coverage booklet, the health plan contract, or the summary plan description. So I want to take a moment to address some of the more common and important terms that you may see in your insurance policy and what they mean. First, copay. The copay is the fixed amount, for example, maybe $15, that you would pay for a covered healthcare service, usually when you get the service. So maybe every single time you see your primary care doctor, it's $15. Maybe every time you see a specialist, like your oncologist, maybe it's $50. Those might vary depending on the policy that you have, but once you sign up for coverage, your copay is going to be the same every time. That helps plan ahead for finances, and hopefully it won't be a surprise when you show up to the doctor and have to pay a copay. Coinsurance, on the other hand, is a percentage that you may have to pay for a given service. So you might know that you have a $15 or $30 copay, which is a standard amount, but for certain services, like for example, an MRI, your insurance policy might say that you have a 10% coinsurance or a 20% coinsurance, which means that it might be a little bit harder to predict exactly how much money you're going to have to pay out of pocket for that given service. You just know that you're going to be paying a percentage of the cost. Deductible is the amount that you owe for covered healthcare services before your health insurance plan begins to pay. So for example, if your deductible is $1,000, your plan won't pay anything until you've paid $1,000 for covered services. Some preventive services are free without needing to meet your deductible first. And the last term that I want to mention is pre-authorization. So you may have to get your doctor to submit a prior authorization to your insurance company in order for a service to be paid. Getting something pre-authorized does not always mean that it will ultimately be covered, which is kind of surprising. But not getting pre-authorization when it's required can make it very difficult to get the insurance company to actually pay for the service after the fact. So another example, an MRI often is something that you would need prior authorization for. One other thing that I want to flag here with respect to insurance policies is that the Affordable Care Act, also known as Obamacare, abbreviated here as the ACA, under the Affordable Care Act, there are a number of requirements for insurance plans. First, children and young adults have to be allowed to stay on their parents' insurance plans up until age 26. Lifetime limits or annual limits are no longer allowed on essential health benefits. So previously, a plan might have been able to say, oh, you've got a $5 million lifetime limit. Well, when you're healthy, $5 million seems like a lot of money. Once you get sick, it could be really easy to reach that lifetime limit and then essentially end up uninsured. So no more lifetime limits. Insurance policies and companies are no longer allowed to discriminate based on pre-existing conditions, and they're also not allowed to discriminate based on gender. So previously, women had to pay more for health insurance than men did. So that's no longer the case. It's also really important to understand your options if you are about to lose or have lost your insurance coverage or are potentially looking to change your insurance coverage. So if you don't have health insurance or are about to lose your coverage, here are a few different options. So COBRA is a federal law that provides for continuation of insurance coverage. It can be very expensive. It applies to employers who have at least 20 or more employees on their plan. And it provides, if you're leaving your job or losing your job, it provides for up to 18 months of coverage where you're able to actually stay on the same exact health insurance plan that you had while you were working. So COBRA is not a new type of health insurance that you sign up for. It's a law that provides you the ability to stay on your same health insurance plan for a period of time. Now, if you don't work for a company that has 20 or more employees, New York actually has a state mini COBRA law, as many states do, that requires small employers, so with fewer than 20 employees, to provide the equivalent of COBRA benefits. So under New York state law, you're entitled to 36 months of continued health coverage at a monthly cost to you of 102% of the actual cost to the employer. So one of the downsides, well, one of the benefits of COBRA or mini COBRA is that you can stay on the same health insurance plan. You don't have to change any of your doctors. You don't have to reschedule any of your appointments. And so for someone going through active treatment, it might be a good option. On the other hand, COBRA is extremely expensive. Generally speaking, if you get insurance through your employer, the employer often pays a pretty significant percentage of your monthly premiums. Unfortunately, under COBRA and under state COBRA laws, the patient or the former employee become responsible for paying the entire cost of that monthly premium, including often an administrative fee. So just as an example, I've heard from numerous people that their COBRA payments just for an individual can be upwards of $1,000 a month. If COBRA is not a realistic option for you for any number of reasons, but often finances are the biggest one, there is another option now as a result of the Affordable Care Act. So that option is to purchase a private insurance plan through the state marketplace, so the New York State of Health. If you are looking for new insurance because you've had a major life event like losing your job, moving, getting divorced, getting married, any of those things, you would potentially be eligible for something called a special enrollment period. It's a period of 60 days where you would be able to opt into coverage, submit an application, regardless of what time of year it is. If, unfortunately, if you're not eligible for a special enrollment period, maybe you've just had a lapse in coverage, or you've waited past the 60 days for special enrollment period, or maybe you're just uninsured and you've decided that now's the time to look for insurance coverage, you're only able to sign up for health insurance coverage during open enrollment. Now, currently, as far as I know, the open enrollment period for New York has not been announced yet. In previous years, it was November 1st to January 31st. Last year, under the Trump administration, many of those open enrollment periods were reduced to November 1st to December 15th. So keep an eye out if you're looking to potentially join a new health insurance plan, or you think that your coverage might be changing or you need to make changes. Do keep an eye out for announcements about this year's open enrollment period. It most likely would not start any earlier than November 1st, so maybe towards the end of October, it's a good idea to start looking out for that. One of the benefits to signing up for a plan through the state marketplace is that if, COBRA is too expensive and if you earn under a certain amount of money each year, you might potentially be eligible for tax credits that would help reduce your monthly insurance premiums. Now, another option that you may have is Medicaid. So previously, before the Affordable Care Act was passed, in order to be eligible for Medicaid in most states, you had to either be a person with a disability, be over age 65, pregnant, blind, some sort of categorical eligibility, and you had to have very limited income and very limited resources or assets. Under the Affordable Care Act, New York and many other states have chosen to expand their Medicaid population. So they've expanded eligibility for Medicaid services, essentially to only consider income. So if your income is at or below 138% of the federal poverty line, which for an individual is around $16,000 a year, then you might potentially be eligible for Medicaid as an alternative health coverage option. Okay, so moving on to CLRC tip number 2, don't take no for an answer. So this is essentially a life tip, that we hear all the time, but specifically it's a cancer-related legal tip in the arena of health insurance denials and disability insurance denials. So I'll talk a little bit about both of those things in this section. If you are denied coverage for a health insurance benefit, you should not take no for an answer, and that means going through a health insurance appeal. Private insurance companies do have different procedures for appeals, and if you have Medicaid or Medicare, the appeals processes are going to be different. But for those with private insurance, the process for completing the appeal should be found in the denial letter sent by the insurance company. So if you are denied, your insurance company is required to provide you with documentation as to why and how to appeal that process. Often medical teams are unaware of insurance difficulties that patients face, and I know a lot of patients feel somewhat uncomfortable with being able to talk to their insurance. Being able to talk to their providers about their insurance issues. So it's a good idea to involve your medical team if you think that you are going to have to submit some sort of appeal. And often the medical team is happy to help with that because they do want their patients to receive the services that they are prescribing. Okay, so another thing that the Affordable Care Act implemented with respect to health insurance is the requirement that people in every state have access to something called an external review or an independent medical review. So if you do appeal to your insurance company and you are still denied, once you exhaust your options with the insurance company, you have the right to an external appeal. An independent medical review, which is what it's called here in California and in a few other states, it's an opportunity to have someone besides the health insurance company decide whether the company should pay for the service you're requesting. So rather than appealing back directly to the insurance company, it gives you an opportunity to engage with a third party who's unaffiliated with your insurance company to help determine whether or not the insurance company was correct in making its initial decision. So here in New York, I'm not there currently. In New York, the external review process is done through the Department of Financial Services, and it's available when your insurer or HMO denies healthcare service as not medically necessary, experimental or investigational, or out of network. Healthcare providers also have the right to an external appeal when healthcare services are denied. An urgent issue qualifies for an expedited external appeal. And often if the situation is very urgent, where someone maybe needs an emergency surgery or it's a matter of, life and death, there is a requirement that the external review is completed within 72 hours. And a patient can request an expedited internal and external appeal at the same time. So if it's really urgent, you don't have to wait for the internal appeals process with your insurance company to be completed before you can move ahead with an external appeal. Okay, so that's sort of the gist of not taking no for an answer with respect to health insurance. So now I want to talk a little bit about Social Security benefits and disability benefits appeals. So before I talk about denial, I'll just introduce the benefits really quickly. So the Social Security Administration operates two different programs with respect to disability benefits. So one of them is Social Security Disability Insurance, or SSDI, and the other is Supplemental Security Income, or SSI. They have the same definition of disability, which is that you must be unable to work due to a severe medical condition that is expected to last for at least 1 year or end in death. So for SSI, Supplemental Security Income, eligibility is based on whether or not you meet that definition of disability, and then also how much money you have in the bank, so your assets, and your income. They don't look at your work history. On the other hand, for Social Security Disability Insurance, or SSDI, eligibility is, again, based on whether or not you meet this definition of disability. And then how much you receive is also based on your work history. So you generally have to have paid into Social Security for at least 5 out of the last 10 years. And after 2 years of receiving SSDI, you're eligible to receive Medicare. So if you are going through an application process for either of these two programs, it's a really good idea to check the Social Security Administration's Blue Book, which gives a list of conditions that the Social Security Administration has already determined are likely to affect a person's ability to work. It's a really good idea to talk to your healthcare provider so that they are aware that you're applying and don't accidentally put things into your medical record that maybe wouldn't look particularly good for an application. They might be able to help with the application process to an extent. You should also look into the Compassionate Allowances Program to see whether or not you have a condition that would qualify you for an expedited review. And then, of course, you should absolutely appeal if you are denied. One of the things that is really challenging is that if you don't follow the appeal deadlines, it's very difficult to come back to the Social Security Administration and say, I'm sorry, I missed the appeal. Can I now appeal later? They generally are pretty strict with their appeal deadlines. And the reason that it's a good idea to appeal as opposed to submit a new application is because most of the appeal denials are later reversed. If you reapply instead of appealing, you could lose out on benefits that you were otherwise entitled to. Starting a new application basically resets the clock. Whereas if you appeal the decision, you're still moving forward in the process and you're not forfeiting any potential retroactive benefits or back pay that you might be entitled to. The appeals process has multiple levels and there are very specific deadlines to appeal, as I mentioned. Usually those deadlines are within 60 days, but pay attention to any paperwork you receive if you're applying for benefits. So this includes simply checking your mail. I know checking your mail is generally not the most exciting thing to do, even if you aren't sick and aren't receiving a bunch of medical bills. But again, like I said, there are really strict appeals deadlines, and this applies to health insurance as well. You certainly don't want to miss out on any deadlines just because you didn't open your mail or didn't check your mailbox. In some cases, hiring an attorney might be the best course of action to help you with an appeal. You generally do not need an attorney to help you during an initial Social Security application. But having one during the appeals process can be very helpful. Okay, CLRC 3, request accommodations before your work performance is affected. It's generally the employee's responsibility to let the employer know if you need help doing your job if you're unable to do so because of a disability. If an employee is not performing his or her job, and the employer does not know about their need for accommodations, he or she can potentially be terminated. Having cancer does not always prevent someone from being let go for performance issues. So I'm going to talk a little bit about those workplace protections and how to make sure you can maximize them. So the Americans with Disabilities Act, or the ADA, is a federal law that prevents discrimination in all phases of employment. So not just hiring and firing, but also benefits, job assignments, etc. The ADA applies to state and local governments and applies to private employers with 15 or more employees. In order to be eligible for protection under the ADA, an employee has to actually have a disability, and the definition of disability under the ADA is actually different from the definition under either of the programs under the Social Security Administration. So under the ADA, the definition is that you have to have a physical or mental impairment that substantially limits a major life activity. So an impairment that maybe affects walking, talking, breathing, eating, any of the sort of major activities of daily living that most humans are able to do. You also have to be qualified for the position, which means that you can perform the essential functions of the job with or without accommodations. So if you are a qualified employee with a disability under the ADA, you are potentially protected by the Americans with Disabilities Act, and you would potentially be entitled to something called a reasonable accommodation. Now, as I mentioned, people with disabilities can still be fired from their jobs or let go from their jobs, but the reason cannot be due to their disability. So if someone's work performance suffers, or if they're late or sleeping at their desk and the company does budget cuts, employees can still be let go even if they have cancer or another disability. This is a common misconception that we hear about, and this is why we added the tip on requesting accommodations before your work performance is affected. So I mentioned that if you're a qualified employee with a disability, as defined under the ADA, you're entitled to reasonable accommodations. An accommodation is a change in the work environment that enables an individual to perform their job. There's no one-size-fits-all accommodation. It really varies from person to person and company to company. What might be reasonable for one person at a given company might not even be reasonable for another person at the same company, because they might have very different jobs. So for example, if somebody works in an office and they do lots of work by way of email and teleconferences and conference calls, maybe an accommodation would be to work from home. If, on the other hand, you work as a cashier, working from home is not going to be a reasonable accommodation because you wouldn't be able to do your job. An employee should notify the employer right away if he or she thinks there's a need for an accommodation, because again, if the employer is not on notice, they might just think, oh, this employee is slacking off, oh, this employee doesn't care about their job because they're showing up late or they're sleeping at their desk, or any number of things. So it's really important to request accommodations as soon as you think you might need one. Now, most states have a state fair employment law that provides similar protections to the ADA. In New York, the New York State Human Rights Law applies to employers with 4 or more employees, as opposed to the ADA, which applies to employers with 15 or more. So if you work for a smaller employer and the ADA does not apply, it's possible that the New York State Fair Employment Law might. I won't go into detail about any of the other requirements under the law, but suffice it to say that they're pretty similar to the ADA. So if you suspect discrimination in employment, it's always a good idea to contact an employment attorney. Most of them provide free consultations, and the CLRC does have a list of attorneys that we can potentially provide referrals to in most states across the country, including New York. Okay, so moving along, CLRC tip number 4, you might be able to take time off of work and keep your job. This comes into play pretty frequently when an accommodation simply isn't enough, or someone really needs to take extended time off for surgeries or other types of medical leave. So the Family Medical Leave Act is a federal law that provides up to 12 weeks of unpaid job and health benefit protected leave per year, either for the employee to take time off for his or her own serious medical condition, or to take time off to take care of a covered family member, such as a parent, spouse, or child. The law is very specific that it only applies to taking time off for yourself or for a child, spouse, or parent, not for other extended family members. In order to be eligible for FMLA leave, you have to work for a covered employer. So generally speaking, this is where people run into some issues because not everyone works for a private employer that has 50 or more employees within a 75-mile radius of where they show up to work. For example, I work for the Disability Rights Legal Center. We have around 20 people on staff, so we are not covered by the Family Medical Leave Act. In addition to working for a covered employer, the employee, his or herself, also has to have worked for that employer for at least 12 months and worked at least 1,250 hours in the last year. So it's not necessary that you work full time. 1,250 hours in a year is about 20 to 25 hours per week, depending on whether or not you've taken other time off. So while you're on FMLA, the employee can choose or the employer can require the use of vacation or sick leave. So I mentioned that FMLA leave is unpaid leave. That usually means that if an employee has vacation or sick time accrued, they're going to want to use that time concurrently so that they are still getting paid while they're out on leave. Usually, we do get questions from people who ask, well, I have 4 weeks of vacation accrued and I'm going to take 12 weeks of FMLA leave, so don't I get 16 weeks off total? Usually the answer is no. Usually you have to use both of those types of leaves at the same time. Okay, so what if you're not qualified for FMLA or you don't have enough time? It's just 12 weeks is certainly not enough time for a lot of people. First, you can check your employer's policy. I mentioned that my organization is not covered by FMLA, but we do have a policy in our employee handbook that lets us know about our rights to take medical leave. Another thing that you can potentially do is request time off as a reasonable accommodation under the Americans with Disabilities Act. Now, in some areas of the country, that's sort of being scrutinized a bit more, where the employer might not actually be required to provide an extension of leave, but it's always a good idea to ask, and to ask before the medical leave has ended. And just a quick note, employers do not have to hold a position open indefinitely. That's one of the hard truths about employment law here in this country, is that regardless of how long someone has worked for a company, how much they've sacrificed for a company, how sick they are, et cetera, most employers are not going to be willing to and are not required to hold a position open indefinitely. Now, one quick thing I want to mention here that's new for 2018 is the New York Paid Family Leave Program. So in addition to providing income replacement during time off, if you're taking time off to take care of a family member, the New York Paid Family Leave Program actually provides job protection as well as continuation of health coverage while out on paid family leave. So the New York program, as I mentioned, it's pretty new. So right now you're able to take paid time off for 8 weeks, and by 2021 it will increase up to 12 weeks. This program is in order to be able to take time off to take care of a spouse, domestic partner, child, parent or step-parent, parent-in-law, grandparent, grandchild. And in order to be eligible, you have to either be working, if you've been working full-time, then you're eligible after 26 weeks of employment, so that's about 6 months. And if you're working part-time, you're eligible for paid family leave benefits after working for 175 days at the company, and they don't have to be consecutive. Currently, the weekly benefit is capped at $652.96, and that will vary. Your weekly benefit does vary depending on how much you are earning. So this law is a little bit different from the Family Medical Leave Act because it, in addition to providing job protection and health insurance while you're out on, or health insurance continuation while you're out on leave, it is also providing paid time off. So I wanted to flag a couple of employment resources, and there are more resources at the end of the slide deck here, but these are a couple of really good resources if you have employment questions. All right, so moving along here, I want to make sure I'm able to leave enough time for questions. So CLRC tip number 5, no matter your health, document your end of life wishes before it is necessary. I unfortunately went to a training several months ago and somebody raised their hand and asked the speaker, who was not me, asked the speaker, at what point should somebody put together their estate planning documents and their advanced planning documents? And the response from the presenter was, oh, well, it's going to depend on how sick the person is. And I was astonished because essentially, no matter what your health is, any healthy person, any person over the age of 18, I think should have some sort of documentation in place because you never know what's going to happen, regardless of whether or not someone has cancer or previously had cancer or is in the hospital or is, healthy and climbing Mount Everest. You never know what can happen, so it's a good idea to plan ahead. Even if you think that everyone that you care about, your friends and family, know about what you would want to happen, if you become unable to make decisions for yourself or once you pass away, if it's not in writing, it might not be sufficient and could leave your friends and family in a very difficult situation, trying to figure out what to do and what you might have wanted. So this is true when it comes to decisions about healthcare as well as decisions about dividing your property. Oh, here we go. So advanced planning can be broken up into 2 parts. So the first part is to plan for your property. So that would be through a will, trust, or a power of attorney for finance. And then there's also the other part of it that focuses on planning ahead for your healthcare. So that would be an advanced healthcare directive and its component parts. So most people have heard of a will, maybe they've heard of a power of attorney, but there are a lot of different tools available for people to make plans for the future. And there are legal formalities that need to be followed to ensure estate planning documents are valid, and the laws do vary from state to state. So in the next few minutes, I'll talk about general estate planning tools and laws in New York, but this is general information, again, not legal advice on what to do in your specific situation. So one of the most common estate planning tools that you've probably at least heard of is a will, also referred to as a last will and testament. And this is a tool that you use to name who gets your property upon your death. So we recommend contacting an attorney familiar with estate planning in the state where you live. So if you live in New York, we definitely recommend talking to a New York estate planning attorney. Because there might be other options that would make more sense for your situation. Whether or not a will makes sense or a trust would be better is something that an experienced estate planning attorney would be able to share with you and sort of advise you on. Generally, to create a will in New York, it has to comply with certain formalities. It doesn't necessarily need to be prepared by an attorney, but it can be helpful to have a lawyer review it with you. So to create a valid will in New York, you have to be 18 years and old or older, of sound mind and memory, which means that you're able to comprehend the nature of what you're doing. So you know that you're creating a will. The will has to be witnessed by 2 witnesses, and those witnesses, again, have to be over 18, and they have to be uninterested, which means that they don't stand to gain anything from the will. So if you're planning to give, your favorite, your favorite New York Rangers jersey to your sister, your sister wouldn't be able to be a witness for your will. In the will, you should also name an executor, and the executor is someone who will carry out your wishes as stated in the will. If you don't name an executor, then the court most likely will name one once your will goes through probate. And probate is the process where the will is actually sort of examined to make sure that it's valid, and then the court oversees the process where your property is distributed. In limited circumstances, a handwritten will would be valid, but again, I don't recommend, I don't think anyone really would recommend a handwritten will. It's really best to have something at least reviewed by an attorney. Now, if you pass away without a will, this is or other estate planning document like a trust, this is referred to dying intestate. State law will then determine where your property goes if you have not provided for it in a will or other estate planning document. If you have not created a will, typically the property will go to your spouse and children. If you have neither, it goes to other relatives like parents, siblings, nieces and nephews, and cousins. And if someone has no surviving relatives, then the property would go to the state. If you don't own much by way of property, maybe you don't really care about having a will in place, but one thing that I really like to try to remind people is that even if you don't own a house or you don't own much by way of property, you know, a lot of people have pets, and a lot of times people sort of forget to make plans for their pets. You know, a will is another place that you can also name a legal guardian for minor children. So keep in mind that even if you don't own a lot by way of actual physical tangible property, you might still really want to make sure that you have made plans for the things that you do own and take care of. Now, another option is a trust, and a trust is an arrangement where someone, you also referred to as the grantor, the settlor, the trustor, transfers legal title to property into a trust. And you do that for the benefit of another person, referred to as a beneficiary. The creator of the trust names a trustee who will manage the property and distribute it for the benefit of the other person, the beneficiary. Usually with a living trust, the settlor or trustor, which in this case might be you, can be the trustee during your lifetime. And then once you pass away, in the trust, you will have named someone else to be the trustee to distribute the property. It's a really good idea to talk to an estate planning attorney to see if a trust makes sense. You know, setting up a will is generally very inexpensive, but then the will has to go through probate, and the probate and court fees can be expensive. Whereas with a trust, there is no probate process, but it can be expensive to set up the trust initially. So I've heard a number of different ranges. I think pretty typical is around $1,000 to $1,500 to set up a trust. But again, it'll vary from attorney to attorney, and you can certainly shop around. So another document that is pretty important that I think a lot of people overlook is the power of attorney for financial affairs. So people who are either nearing the end of their lives or people who are going through intense treatment, maybe are in and out of the hospital, often need assistance in managing their financial affairs. So a power of attorney for financial and business affairs is a legally binding document that you can prepare. Usually you don't need a lawyer to set one of these up. There's often free forms available online. And you would choose a trusted person, known as your agent, to make financial or business decisions for you. So that means that they can manage your finances, they can dispose of your property, they could sell your property. You wouldn't lose authority to manage your finances unless you become incapacitated or unable to make decisions for yourself. So we've heard this come up pretty frequently. If someone's in the hospital and they're not able to get to the bank to cash a check, or they don't have access to their checkbook to, pay their mortgage. In these situations, it might be helpful to have a power of attorney for financial affairs so that a trusted person can help manage your finances while you're maybe don't have the time or energy, or potentially are incapacitated and are unable to make those decisions on your own. So really quickly here, I'm going to move on to advanced planning for healthcare. So in addition to thinking about what you want to happen to your property and finances, please be sure to plan ahead for your healthcare. People often put this off, but as I mentioned before, regardless of your health status, everyone should provide some instructions on their healthcare in case of an illness or in case of incapacity, so that families and loved ones are not left trying to guess what the patient might have wanted. No matter someone's age, you certainly might not want to name your parents as your healthcare proxy, because the person that you're going to be naming in this document, an advance directive, is someone that you're going to want to trust to follow your instructions or to do what you would like with respect to your end of life wishes. So an advance healthcare directive is a written set of instructions that state a person's wishes about the medical care and treatment that they want, if they're unable to make decisions for themselves. In New York, there are 3 different parts: the healthcare proxy, the living will, and then possibly the do not resuscitate order, although that's not necessarily always included. So a healthcare proxy allows you to appoint an agent to make healthcare decisions for you if you become unable to make decisions for yourself. And then a living will is a written declaration of your healthcare wishes. So the living will is where you can get as specific or be as vague as you want about the types of treatments that you may or may not want if you become incapacitated, and they can really serve as a guide for your proxy. So it can be really helpful to set up both parts of that advance directive so that not only do you know that someone you trust is going to be there to make decisions for you, but you also have set up some sort of guide for them to help make those decisions. There's also something called a medical order for life-sustaining treatment. And in this document, a doctor would record your preferences for medical care and end-of-life wishes. It translates current medical treatment preferences into a physician order. So this would actually become part of your medical record. It's not meant to replace a healthcare proxy or living will. And those 2 things, or the advance directive, instruct on future medical care, whereas a medical order for life-sustaining treatment is more applicable to current treatment for people who are generally nearing the end of their lives. Okay, so I think I was able to save just a couple of minutes for questions here. Just a quick recap of our 5 tips. It's the patient's responsibility to understand his or her health insurance coverage. Don't take no for an answer. Request accommodations before your work performance is affected. You may be able to take time off of work and keep your job, and document life wishes before it's necessary. I'm going to just share a couple of resources. I will be sharing the slides, and I know that the webinar is also going to be posted. So there are a couple of resources here that might be helpful, both with respect to employment, with respect to Social Security benefits. There's a few more resources here. Again, employment, Social Security benefits. There are free advance directive forms available on caringinfo.org. And then now I'm happy to open it up for questions. I don't see any currently, but if you do have questions, please feel free to type them into the chat box. I'm going to end the recording right now, but I'm happy to stick around for a couple of questions if there are any.